यही है ना। तो अगर वो साइलेंट है इस पॉइंट पे, ही डजंट डिस्क्लोज इन डिफेंस, तो उसके खिलाफ साबित तो हो गया। दिस इज नॉट ड्यूटी ऑफ द प्रोसिक्यूशन। प्रोसिक्यूशन की ड्यूटी ये थी कि वो सुन ले बात। प्रोसिक्यूशन की ड्यूटी थी कि वो बताते कि जी ये है आपके खिलाफ मटीरियल, आप इसको रिबट करें, एंड यू आर नॉट इन पोजीशन टू रिबट दैट इन डिफेंस। So what will be the presumption? Now come to that point.
Your Honor, as I've already stated, in the case law, that a charge of corrupt practice must be affirmed. The benefit of any doubt raised upon the evidence must go to the accused. And the evidence that forms...
What is the basis of doubt?
Your Honor, the report, the corrupt...
Which
practice,
report?
The corrupt numbers. The corrupt numbers report, which form the basis of the bar to contest election upon a person who has committed a dishonest act.
Can a subordinate legislation override the consequence of the constitutional provision?
No, it cannot. It has persuasive value. It is not. It has persuasive value.
Then why are you arguing this point that the section 232 stipulates a certain period, whereas there is no certain period provided in 62(1)(f)?
Your Honor, it is the rule of interpretation that previous...
Can you cite any judgment on that point?
और किस हद तक पनिश कर सकते हैं? So if it's silent, don't you think it has given enough room to the judiciary to discretion to court की, that's correct, discretion to the court कि जी आप जैसे in the light of Islamic principles, should this honest person be allowed to hold public office?
Your rights, there is a rule, sentential legis or rule of liberal in interpretation, which is to be applied in case of ambiguity, uncertainty or incomplete meaning of the statute as to ascertain the true intention of the legislature. The essence of law lies in the spirit, not in its letter, for the letter is significant only as being the external manifestation of the intention that underlies it. Imposition of a lifetime bar to contest for election is against the principles of harmonious interpretation of the provisions of Constitution as it abridges the fundamental rights.
Is convicted and it's proved that he was a corrupt person. You can say expressly that court cannot say that he is disqualified. So far as this fact is concerned, he is corrupt, that is sufficient to prove it. So law will take its own course.
It was not proved. It was not supported by any concrete evidence.
हाँ, वो बताएं कौन सी है? वो हम उनसे भी कह रहे हैं.
It is our stance that it is not mentioned in the facts. What was the evidence?
What is that?
He has to justify.
Just a minute.
Yes, Your Honor.
देखिए, एक तरीका है ना ट्रायल का.
So the second question didn't raise from where those assets come from. He denied the allegations that he is not the owner of those assets. Shall I proceed?
Sure.
Yes.
Your Honor, it is violative of Article 10A, the right to fair trial. As Article 10A ensures that the person shall be entitled to fair trial and due process of law. And it is also violative of the Article 17.
How it is violative of 10A? For the determination of his civil rights and obligations or in any criminal charge against him, a person shall be entitled to a fair trial.
Appeal and revision. Any person convicted on the Prosecutor General accountability if so directed by the Chairman NAB, aggrieved by the final judgment and order of the court under this ordinance, may within 30 days of the final judgment and order of the court prefer an appeal to the High Court, under whose judgment where the court is situated. In our case, all the due process was followed. Hassan Ali Shah was charged by NAB. After that, he was not satisfied by the decision of the NAB court, and by section 32, he appealed that in High Court. So the whole procedure was followed, which is given to him by the lawyer. The provisions of the Constitution and the law, Supreme Court directed that the respondent should seal the hold of the public office, National Assembly with immediate effect.
This is what I am asking. The bare reading of Article 62(1)(f) provides there is no specific time period. So when the NAB court had already disqualified him for 10 years, then why this lifetime disqualification, which was not even written in the Constitution itself?
Highly obliged, Your Excellency. Supreme Court is for the interpretation of the law. That's why the Supreme Court interpreted 62 in these.
And which principle of interpretation was applied here?
Apologies, Your Honor. Respondents are unable with this question. Unable to assist.
It seems like a liberal interpretation.
Apologies, Your Honor.
Friends, there is no problem article being there. It is there and it has not been changed so far. The question is how you are making it a lifetime stipulation in it. Is it provided in law? The answer is no. Then if the Supreme Court had interpreted it, under what are the parameters before the Supreme Court in that regard to give a lifetime ban in that regard?
Highly obliged, Your Excellency. Your Excellency, to answer this question, we should see what are these words and what they meant. Your Honor, the requirements of a person to be sagacious, righteous, we have to see the requirements. The terminology is defined by the Honorable Court, Your Honor. The term sagacious means 2013 CLC 1193. I will ask my searcher to provide the Honorable Court with the case law in which the sagacious word is defined. The word sagacious denotes a prudent person, skillful in statecraft or management, having prompt.
We are not challenging.
Your Honor, in the case of PLD 2008 Lahore 421, that will be provided to the Honorable Court and searcher. Your Honor, in the case of Noor Ilahi versus Mia Mohan Nawashri, PLD 2008 Lahore 421, it is stated as a result of the above findings, respondent 1 is declared as disqualified to contest upcoming by-elections. Your Honor, it was stated that High Court could make a declaration with respect to Article 62(1)(f) and could declare, hence it can declare a person under.
Just go through your case. This petition was filed under what law?
Your Honor, we do not have the complete.
You have it. You have just submitted before the court.
Yes.
So the facts have maintained that in para 14 of the Moot proposition, High Court convicted him with a change, and it is mentioned in para 15 of the Moot proposition that the right to fair trial was violated by High Court as he wasn't charged for the offence, which subsequently means that he was not notified about the charges. They were unable to assist the Honorable Bench in this regard. Your Honor, they have also stated that these qualities cannot be equal and they are subjective. That proves my stance that disqualification for lifetime on such basis is not a rational consequence. They have also completely disregarded the principle
Given to their client. Your Honor, it was a statement in the fact by the lawyer of Hassan Ali Shah that our fundamental rights has been violated. There was no judgment of the court. That was just mere statement by the lawyer of Hassan Ali Shah out of the court in front of press. Moving forward, the learned appellants have perceived that it is in the article, there is a concept of Toba. Right now we were discussing Article 62(1)(f). In that particular, Your Honor, article, there are no certain concept of Toba in the Constitution which is written. Moving forward, the right to fair trial and due process was clearly established by the respondents that the right to fair trial and due process was followed. He had given every chance to appeal in front of High Court and then Supreme Court. Is the Honorable Court, am I here for any other assistance of the court?
For bench में बैठे हुए, I'm the most incompetent and inexperienced person. So जितना थोड़ा बहुत whatever the little I know वो आपको बता देता हूँ. जैसे हमने एक बात की है कि आपके facts पे control होना चाहिए, and I must quote Ijaz Batalvi साहब. Control the facts, law will take its own course. So that's important. The facts are. दूसरा मेरी ये खास किस्म की ओपिनियन है मूट्स के बारे में कि जो प्रोपोजिशंस फ्रेम की जाती है, भी राना साहब को मैं डिस्कस कर रहा था कि आप लोगों का दूर दूर तक उससे पाला नहीं पड़ना व्हेन यू विल कम टू द प्रोफेशन. उसके बावजूद द वे यू और उन्होंने इस प्रोपोजिशन को हैंडल किया, डील किया, इट्स एक्सेप्शनल, वेरी गुड, आई एम वेरी गुड. बिकॉज माय बैकग्राउंड इज द क्रिमिनल लॉ. And the people who practice on criminal law, they say they are the rock stars of the law. like Salman Safdar, Azam Rizal, or some stalwarts like that. Faujdari wakalat. So I will be giving you the reference with Faujdari wakalat. If you can't think on the spot, trust me, कि आप कोई दीवानी चैम्बर ज्वाइन करें, कोई टैक्सेशन की प्रैक्टिस करें, कॉर्पोरेट ट्रांजैक्शनल काम करें, criminal law के लिए you need to tame your mind and body to think at the spot. So we were trying to shoot questions at you, और उसके ऊपर जिस तरह आप लोग response कर रहे थे, that was exceptional considering the fact all of you are the law school students, or you are going to make a good name in the profession. So उस वजह से एक चीज जो मैं I would really like to suggest both the teams. When you start your argument, you need to see what is the issue of that proposition. Make your argument surrounded that issue. Because most of the time, the questions coming in the court or in the moot court by the judges will be revolving around that issue. आप जब इस रोस्टर पे खड़े होते हैं ना, तो आपने अपने केस के साथ साथ उस जज को भी कंट्रोल करना होता है कि आप उस इशू के इर्द गिर्द उसे रखें, ताकि जो आपकी प्रेपरेशन है, प्रोबेबल प्रेपरेशन है, वो उसी हद तक कन्फाइंड रहे, ताकि इधर उधर ना चली जाए. So इस वजह से जो आपकी प्रोपोजिशन थी, that was revolving around section 9, 15, 62, 1F, 63, 199. So there was ample material if you would have gone through that material कि उसको किस तरह सराउंड करना था. So इस वजह से एक जिस तरह डॉक्टर के बारे में कहा जाता है ना कि यार इस डॉक्टर का डायग्नोसिस बहुत कमाल का है, इसी तरह एक लॉयर के बारे में कहा जाता है कि जब आप इसके पास कोई मसला लेके जाते हो, तो जो असल आपका रिलीफ है यार, उसका ये डायग्नोसिस बहुत कमाल करता है, क्योंकि आपको इधर उधर नहीं लेके जाएगा, आपको एक्चुअली आपके रिलीफ की तरफ लेके जाए. दैट्स द स्किल यू नीड टू लर्न, पोजेस, और ये ओवर द पीरियड ऑफ टाइम आएगा. दूसरा, टॉपर्स लॉ कॉलेज और राणा साहब को मैं एक सजेशन दूंगा कि आप लोग एक चीज मैंडेटरी करें अपने बच्चों के ऊपर, चाहे वो LLB पार्ट 1 का स्टूडेंट हो, सेमेस्टर सिस्टम का, कि वीकली इन्होंने अदालत के अंदर जाना है. एंड अदालत इज नॉट हाई कोर्ट और द सुप्रीम कोर्ट, द मैजिस्ट्रियल कोर्ट्स, द सिविल कोर्ट्स, और दे शुड सिट इन द कोर्ट एंड सी व्हाट इज हैपनिंग. ट्रस्ट मी, आप लोगों की जो जनरेशन है ना, कि जो बैठी हुई हमारे सामने, हम लोग हमसे पहले, जैसा कि आप देख लें, किताबें पढ़ के, रिसाले पढ़ के बुरा हाल हो गया. यू गाइज बिलोंग टू अ जनरेशन जो विजुअल लर्निंग की जनरेशन है. आप लोगों का कंसंट्रेशन स्पैन इस तरह नहीं है कि रिसालों को पढ़ें, रिसाले मीन्स द लॉ जर्नल्स, स्टैट्यूट्स को पढ़ें. तो जो एक्चुअल अदालत में जाके जब आपके सामने कुछ होने लगा हुआ है, यू गाइज विल लर्न अ लॉट फ्रॉम दैट. क्रॉस एग्जामिनेशन क्या है, एग्जिबिट क्या चीज है, मार्क क्या चीज है, जज क्या बैठा हुआ है, प्लेंटिफ ने किधर बैठना है, डिफेंडेंट ने किधर बैठना है. अच्छा, उसके बाद शिनाख्त परेड कैसे होती है, कब्र कुशाई कैसे होती है. दीज आर वेरी फैसिनेटिंग कॉन्सेप्ट्स